Houston Maritime Injury Attorneys. A maritime attorney injury lawyer can help you navigate the waters when you are hard working a maritime job. There are many types of accidents and bodies of law that apply when you suffer a maritime accident. Call a Houston Maritime Injury Attorney for a free consultation. What is a maritime accident? A maritime accident refers to an accident injury involving persons working on or around navigable waters, bodies of water used for interstate or international commerce, including interconnected systems of lakes, rivers, seas, and oceans. This often involves injuries sustained while working on oil platforms, boat cargo ships, and other seafaring vessels all along shoreline docks, sea terminals, or rivers around or connecting to the Gulf of Mexico. What type of maritime claim can I file? Depending upon the injured person's status, he may have several types of claims available to file, including a claim under the Jones Act, Longshore and Harborman's Act, or state common law personal injury laws. A maritime injury lawyer can determine the proper status of an injured worker so that the right claim may be filed. The Merchant Marine Act of 1920, also called the Jones Act, is one of example of a federal maritime law that protects workers and provides them with compensation for a work injury or injury aboard an ocean or sea vessel. Those who work on offshore oil rigs are generally covered by the Jones Act as well. While the Jones Act provides you with comprehensive benefits after your injury, it can be complicated to determine if you are covered under the Act and to make a claim. For help, contact Simons and Fletcher PC today. We have represent injured maritime workers throughout Texas and the surrounding areas, and our Jones Act lawyers can put our legal expertise to work for you. Am I eligible for a Jones Act claim? The Jones Act covers sailors, seamen, and other maritime workers who are working aboard either on ocean or sea vessel that is not fixed to the ocean floor. Those working on oil rigs, offshore platforms, or an SPV may also be covered under the Jones Act. If you are an eligible maritime or offshore worker and you qualify for benefits under the Jones Act, you also must prove that your injury occurred in the course of performing work duties and that your employer was negligent in some way that led to your injury. This is different from state workers' compensation protection, which provides workers with coverage regardless of whatever an employer was negligent. It is also important to note that those who are not eligible for a Jones Act claim may be eligible to make a claim for compensation under the Longshore and Harbor Workers Compensation Act. Generally, there is a maximum 3-year statute limitation on maritime claims. Another question: what compensation can I get under the Jones Act? The Jones Act allows not only for coverage of medical costs and payment for disability and or reduced income earning potential, but it can also provide compensation for pain and suffering and other economic and non-economic. It provides more comprehensive coverage than either state's workers' compensation benefits or the Longshore and Harbor Workers Compensation Act. This is an important difference from the benefits or the Longshore and Harbor Workers. This is an important difference from the Longshore and Harbor Workers Compensation Act, which does not provide any payment of pain and suffering. What is the Longshore and Harbor Workers Compensation Act? The Longshore and Harbor Workers Compensation Act takes the place of state workers' compensation laws to allow benefits to workers who are injured when performing certain designated maritime activities. State workers' compensation does not cover maritime workers. Who does the Longshore and Harbour Workers Compensation Act cover? The Longshore and Harbour Workers Compensation Act covers individuals who work on the navigable waterways of the United States or who work on the areas adjoining the navigable waterways of the US.